on April 29, 2024 in Harris County, Texas. The defendant threatened to kill the complainant and the child that they shared together. Complainant felt in fear and pepper sprayed the defendant while on the phone with the 911. Defendant admitted to the threat, stating it was out of anger.
A man stood in a Texas courtroom and told a judge to his face that he threatened to kill the mother of his own child. He admitted it. He said it happened at 4 in the morning, and somehow, by the end of the hearing, he was walking out the door. How does a threat like that end in freedom instead of a jail cell? Keep watching, because the answer says more about our justice system than almost any case you'll see this year. This is the case of Mr. East, a man already on felony probation in Harris County, Texas, for assault of a pregnant person, a charge involving his own sister.
The road to hell is paved with good intentions, Mr. East.
No, sir.
Probation is a court-supervised alternative to prison. It comes with conditions. Break those conditions, and the original sentence can be reinstated.
You're on a very serious probation for assault of a pregnant person. And now, picked up terroristic threat. You're now facing another year in
Mr.
jail.
East was already living under that threat when, according to the criminal complaint, he picked up a brand new case. On April 29th, prosecutors say he threatened to kill the mother of his child and the child too during a phone call. She was so afraid she called 911 while he was still on the line.
Another year in jail. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes, sir.
You have the right to have an attorney present. If you cannot form one, one will be appointed to you. I don't even know what happened to your case. All I know is
He
that you're on
admitted it. Right there in the probable cause hearing, the prosecutor read it into the record. Mr. East told officers he made the threat out of anger. He said he never intended to follow through. But intent doesn't erase the words. In Texas, a terroristic threat doesn't require proof you meant to carry it out. It only requires proof you meant to place someone in fear. That's the legal standard. And by his own admission, he met it.
What do you think? What other prior, does he have any other prior criminal history from anywhere else? Juvenile?
So, Judge, his priors are all in county. He has assault of a pregnant person that he's on probation for against his sister, and an AFM, which was, it looks like it was.
So he has another assault.
He has an AFM from
22.
I think it was the same.
It was refiled. So it was an AFM that was refiled to assault a pregnant person.
That was the sister. The complaint was his sister.
Correct.
Not the
Complainant
same
on that
complaint.
case was his sister, and the complainant in this case is the child of, or the mother of
His child.
Now here's where the case gets complicated and where the open loop starts to crack open. The judge asked the obvious question, what set this off? The answer wasn't a custody dispute, or a financial fight, or even an argument about the baby. It was a text message. Mr. East told the court he'd been asleep when his girlfriend, a woman who was not the mother of his child, called and texted him in distress. When the mother of his child saw those messages, the confrontation began.
The complaining witness.
What was the tipping point here? Why did he get so angry?
4:00 in the morning.
4:00 in the morning.
I had got a phone call from a girlfriend of mine because she was having some problems of her own, but I was sleeping and I didn't hear her phone call or her texts. So while I was holding the baby, I asked her.
4 in the morning.
He admitted he was the one who responded to another woman at 4 in the morning while holding his infant.
In the morning.
4 in the morning.
Yes, sir.
I believe he responded to some text from another female judge, and that's what caused the altercation between him and his mother of his child.
The fight that followed ended with him pepper sprayed by the woman he later threatened to kill.
We've talked about this. But he did not assault her, and as a matter of fact, he was pepper sprayed himself during the course of the altercation after he made the threat. He admitted to the officers that he made the threat out of anger. He had no intention of following through on it. He is gainfully employed. He just started his job last week. Hopefully he still has it. He hasn't been.
Sit with that for a second. The same man who escalated a private betrayal into a death threat was, moments later, asking a judge for mercy. This is where the defense attorney becomes the hero of this hearing and where the real tension begins. The attorney did not deny the threat. He did not pretend the case was weak. Instead, he built his entire argument on something judges are required to weigh but often ignore under public pressure: the difference between a threat made in anger and a defendant who poses an ongoing danger. He pointed out that Mr. East had never missed a court date. He had no flight history. He had just started a new job. He had a fixed address.
You know, I'm not,
He's a lifelong resident of Harris County, Your Honor. He's not a flight risk.
I'm not, my concern is the public.
I understand. And the conditions are right now, he does have a place to stay. He lives on Tidwell. The mother of his child lives at a different location. And
Every factor the law says should matter in a bond decision, the attorney laid out one by one, refusing to let the emotional weight of the threat overwhelm the legal standard for detention.
Same thing, but I would never touch my child's mother. I would never.
Patient for the very same thing, Mr. East.
I understand, sir.
I don't know, Carl. I don't know.
Think about that the next time a coworker is judged entirely on the worst thing they ever said in a meeting, while no one asks what kind of employee they've been every other day.
Mr. East, what do you do with your life now?
Right now, I'm working at a thrift store. I'm not getting paid that much, but I'm getting paid just enough to take care of the child. And right now,
How are you going to take care of a child? You can't even take care of yourself, Mr. East.
I'm still learning. This is my first child, Your Honor. This is my first child, Your Honor. And
You know, the problem is that with all the anger that you have, if a child sees it, what are they going to do?
they're gonna feed off that same energy, sir.
Right.
And
They're going to be just like you.
thank
If
you.
they see you beat mama, threaten to kill mom, what are they going to do?
Context isn't an excuse, but the law says it has to be part of the equation. That's exactly what this attorney forced the court to confront. And here's where the judge does something that separates this case from 1,000 others. He didn't simply release Mr. East. He didn't simply lecture him either. He issued a conditional bond, sometimes called a bond with strings attached, meaning freedom isn't free. It's earned in increments, monitored, and revocable at the first violation.
Bond forfeiture for, he's not failed to appear in court. He's not a flight risk.
I will make you a deal, Mr. East.
Yes, sir.
The only way, because I think that everybody should be given a chance.
Yes, sir.
You weren't given a chance here. You're on probation, which is a serious.
Serious charge.
What I want to see, though, is you proactively addressing your anger.
Yes, sir.
The only way I will let you out is if you take it upon yourself.
The condition 3 anger management classes a week, proof delivered in writing every single Monday in person to the court.
3 times a week
Yes,
to
sir.
do anger management classes somehow, some way.
Yes,
And
sir.
I want proof on a written piece of paper that you're actually doing some kind of anger management
Yes, sir.
3 times a week.
Can we make it 4 times a week? I'm sorry to interrupt you, Judge.
3 is sufficient.
You need to do something that's realistic.
Yes, sir.
Don't overkill because you're setting yourself up to fail.
Then the judge said something that should stop you cold. He told Mr. East, who was dangling the keys to the jail in front of him, not as a threat, as a fact. 1 missed Monday, 1 missing piece of paper, and the bond would be pulled immediately with no one left to
Setting
post it
yourself
again.
up to fail.
Yes, sir.
All I want is you to address it. And the way that I can do that is by dangling a jailhouse key in front of you. So you hold the keys to the jail. I want you to do 3 anger management classes a week.
Yes, sir.
And I want you to bring it proof to me every Monday that you've done 3 classes a week.
Yes, sir.
And the first time you falter, I will yank the bond and I'm going to put you in jail. You now know that you have no one to bond you out. So if you go to jail, you will be stuck like Chuck.
Yes, sir.
You understand?
Yes, sir. I understand.
If you-
That's the line that will end up clipped and shared everywhere because it captures something most court hearings never say out loud. Freedom in this system is conditional, fragile, and entirely in the hands of one person behind a bench. But should it have been granted at all? A man admits to threatening to kill the mother of his child, and the resolution is anger management classes and a promise. Is that accountability, or is that the system protecting a defendant because he didn't fit the profile of who usually stays locked up? That's a question worth sitting with, because reasonable people watching this hearing will land on very different answers. The judge was careful to add real teeth to the order. No contact with the complainant. No contact with his sister from the prior case either. No weapons. Mandatory documentation every week. If those classes don't happen, or if he comes within reach of either woman, the next hearing won't include a deal.
Yes, sir.
Judge, do you want him to have no contact with the complaining witness, or do you
I would
want him to
say
have no
until
contact?
things are better, yeah, no contact and no weapons.
Present time.
Yeah. With this one and the other probation case as well. Yeah.
Understand, but
Yeah.
other probation case, the complainant there was his sister. You want no contact with her also?
Yeah.
Okay, fine. Just want to make sure he,
It's probably already a condition of the felony probation.
well, I understand. I just want to make sure that he understands while he's here.
It's already stated that I shouldn't have contact with Malaysia triplet or have any.
Stop. You know what's expected of you.
Yes, sir.
That's the only thing that matters.
Yes, sir. Thank you, Your Honor.
Thank you, Your Honor.
Thanks, Carl.
But here's the frustrating truth underneath the relief. The system gave Mr. East exactly the kind of individualized review that due process is supposed to guarantee. It is also the same system that, for other defendants without a steady job, a fixed address, or an attorney willing to fight every factor on the record, often results in immediate detention for far less serious allegations. The law was followed here. Whether it was followed fairly for everyone in that courtroom that day is a different question entirely, and the system isn't built to answer it out loud.
Carl, I'd like to know who the extramarital person is, and we need to cut that off so that there are no reasons for her to get upset or you.
Yes,
You
sir.
focus on one and you focus on that child.
Yes, sir.
Understand?
Yes, sir.
This is the only chance you're going to get from me. You will not get another one. If you don't believe me, look around.
I believe you, Your Honor. I believe you, Your Honor.
What this case ultimately teaches is that the law rarely delivers clean endings. It delivers conditions, deadlines, and second chances that are always one violation away from disappearing. Accountability in this courtroom didn't look like punishment. It looked like surveillance paperwork and a judge willing to bet publicly that consequences could change behavior before tragedy did. If you want to see whether that bet paid off, or whether you think this case deserves a harsher outcome than it got, leave a comment below and tell us. Tell us which courtroom case you want broken down next. And if cases like this matter to you, subscribe and share this video, because an informed public is the only real check on a system this complicated.